The committee will come to order. A quorum being present, without objection, the chair is authorized to declare recess of the committee at any point. Pursuant to Committee Rule 3 and House Rule 11, the chair announces that the chair may postpone further proceedings today on any vote relating to any matter under consideration during today's markup. Without objection, all members will have 5 legislative days within which to revise and extend their remarks and to submit additional materials to the chair for inclusion in the record. I now recognize myself for 5 minutes on the measures under consideration today. Today, this committee will mark up 9 bills. This week, we celebrated Veterans Day. As members of Congress, we have a responsibility to ensure that our veterans receive the services and care they need after their service to our nation ends. Today, we will consider H.R. 2398, a bill by Representative Peters to expand the eligibility for the Housing and Urban Development Veteran Affairs Supportive Housing, or HUD-VASH, program. To veterans experiencing homelessness who have received an other than honorable discharge. We must also ensure that our service members are not harassed by predatory debt collectors. Today, we will take up H.R. 5003, that is 5003, the Fair Debt Collection Practices for Service Members Act, a bill by Representative Dean that amends the Fair Debt Collection Practices Act to prohibit debt collectors from threatening service members or their families to have a service member's rank reduced, have their security clearance revoked, have them prosecuted under the Uniform Code of Military Justice, or communicating with the service member's chain of command to locate a service member. In addition, the committee will consider several other bills at this markup to increase protections for consumers and small businesses against unfair or predatory debt collection practices. These bills include H.R. 3490, the Small Business Lending Fairness Act, a bill by Representatives Velasquez that would amend the Truth in Lending Act, that is TILA, to restrict the use of predatory small business loan contract clauses called confessions of judgment. H.R. 3948, the Debt Collection Practices Harmonization Act, a bill by Representative Meeks that clarifies that private debt collectors who pursue debts such as municipal utility bills, tolls, traffic tickets, and court debts are subject to the Fair Debt Collection Practices Act. H.R. 4403, the Stop Debt Collection Abuse Act, a bill by Representative Cleaver that extends the FDCPA's protections as it relates to debt owed to a federal agency, limits the fee debt collectors can charge, and clarifies that debt buyers are subject to FDCPA. H.R. 5001, the Non-Judicial Foreclosure Debt Collection Clarification Act, a bill by Representative Clay that reverses the recent Supreme Court decision in Obdusky versus McCarthy and Holthus, LLP, by amending the FDCPA to clarify that entities in non-judicial foreclosure proceedings are covered by the law. H.R. 5013, the Small Business Fair Debt Collection Protection Act, a bill by Representative Lawson that expands the FDCPA's protections to cover small business loans. And H.R. 5021, the Ending Debt Collection Harassment Act, a bill by Representative Presley that amends the FDCPA to prohibit a debt collector from contacting a consumer by email or text message without a consumer's consent to be contacted electronically, and prohibits the Consumer Financial Protection Bureau from issuing any rules implementing the FDCPA that allow a debt collector to send unlimited emails and text messages to a consumer. In addition, we will mark up a bill from the other side of the aisle, H.R. 2445, the Self-Employed Mortgage Access Act, legislation introduced by Representative Emmer that requires the CFPB to update its regulations to better enable lenders to qualify would-be homeowners who have non-traditional sources of income. I thank the members for their outstanding work on these important measures. I now yield 5 minutes to the distinguished ranking member, Mr. McHenry, for his opening statement on these measures.
Well, thank you, Chairwoman Waters. Thank you for holding this markup. I'd also like to thank her for taking to heart my observation from the last markup and including another Republican bill another bill authored by a Republican in this markup, HR 2445, the Self-Employed Mortgage Access Act of 2019, introduced by Mr. Emmer of Minnesota, who will be the new Republican lead on the FinTech task force. This is a good bill that addresses an emerging issue in our economy, which is how to support non-traditional workers like those in the gig economy. I believe that HR 2445 is a good example of how we need to look outside the box to support these workers. It's a rifle shot. It's a narrow bill that does an important thing for an important group of Americans. I'd also encourage the chair to continue to look at Republican-authored bills for solutions that grow our economy, protect consumers, create jobs, and help support our veterans. For example, H.R. 2904, authored by the gentleman from Kentucky, Mr. Barr. It's called the Financial Protection for Our Military Families Act. It's another strong bill that protects our men and women in uniform under the Military Lending Act. As we pay tribute to the men and women and their families who dedicate their lives to our country, we should ensure they benefit from the consumer protections they are afforded under the law. With respect to the remaining bills, I'll say this: Republicans share the belief in consumer protection and policing bad actors. No one should be intimidated or subjected to harassment or subject to predatory lending practices. However, individuals, small businesses, local and state governments, and the federal government also have the right to be repaid for loans or credit extended or to be repaid in a timely manner. How these rights and protections are balanced are currently set out in the Fair Debt Collection Practices Act. And I know the chair agrees there are aspects of FDCPA that should be updated. I agree. Republicans agree. But I'd say to the distinguished chair, rather than taking the rifle shot approach on this act, on federal government debt and state and local debt in two separate bills, why don't we take a crack at wholesale reform in a bipartisan way to FDCPA, one that reflects the new technology that's available over the last, let's say, 50 years, and the ways that people communicate with each other in, let's say, I don't know, my lifetime. So I think reforming that act would be a great way to modernize. This bill contemplates issues that consumers and lenders are facing in the 21st century. That's the type of bill that I think is necessary and important to support. And so we're going to have a lively debate on this markup. I'm interested in the schedule for today and tomorrow, and we'll inquire of the chair of that. But at this time, I'd like to recognize my colleague, Mr. Lukemeyer from Missouri, to make an announcement about a very important full committee staffer that we have, our legislative counsel on banking issues, Mr. Chris Brown. I'd like to yield to the ranking Republican of the banking subcommittee.
Thank you, Mr. Chairman, our ranking member, and appreciate the opportunity to say a few words about Chris, who's been working for the committee since January. He worked for me for 9.5 years and did a fantastic job. His expertise and his hard work, his work ethic are second to none. He brought a lot of common sense and a lot of pragmatic approach to the issues of the day. But like a lot of our great staff around here, once you gain a lot of experience and earn the respect of other folks, especially downtown, they start looking around for people who can assimilate into their organizations and bring them a lot of prestige and opportunities. And so he's been offered that opportunity, and I certainly admire him for taking that chance. I know that his wife and 2 young sons are going to be excited about having him home probably a little more often than what he has been here. But and I look forward also to seeing him in his new job perhaps come by the office a little more often and talk to us about all the important issues of the day with regards to financial service industry. So, Chris, we wish you well on your new endeavor, and I look forward to seeing you again in a new capacity. Thank you very much for all your service.
Mr. Chairman, our staff, as members of Congress, as members of this body, our staff on both sides of the aisle are so important. And we're grateful for their public service, their willingness to serve for a period of time, some longer than others. In this case, Chris has been on the Hill for just over 11 years. That's significant service. And so, Chris, we wish you well in your future endeavor and your next endeavor. And we thank you for your service to our country, to this committee, to this jurisdiction you so love. So thank you, Chris. Thanks. Thanks.
Let me also express my appreciation for Chris. I've been on the committee a long time, so he's been here the entire length of time, and he is someone who is certainly a reflection of what we want in Congress, staff members who are trying to help us do our jobs well, and somebody who's also willing to and interested in having dialogue with both sides of the aisle. We can't get enough of that from my perspective. So thank you very much. We wish you well. You're sacrificing a great amount of money here in the working for Congress to go into the private sector. And so that's what makes it even more significant.
Thank you, Mr. Chairman. I yield back.
The chair now calls up HR 4403, the Stop Debt Collection Abuse Act of 2019. The clerk will report the bill.
HR 4403, a bill to amend the Fair Debt Collection Practices Act to restrict the debt collection practices of certain debt collectors, being enacted by the Senate and House of Representatives of the United States
Without
of
objection,
America.
the first reading of HR 4403 is dispensed with. The chair has an amendment in the nature of a substitute, copies of which have been distributed in advance and are on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to HR 4403, offered by Mr. Cleaver of Missouri. Strike all after the enacting clause and insert the following. Section 1, short title. This act may be cited as the Stop Debt.
Without objection. The amendment in the nature of the substitute will be considered as read and considered base text for purposes of further amendment. I now recognize myself for 5 minutes to explain my amendment. I would like to thank the chairwoman, first of all, for her support on this legislation, and thank my colleagues and subcommittee ranking member French Hill for his leadership on the measure as well. The debt burdens are deafening to many of low-income Americans who've been saddled with higher debt. As many of you know, low-income Americans are in trouble. These debt burdens are caused by stagnant wages and increased wealth and income inequality, while costs for housing, medical care, and education continue to grow. While these problems facing consumers are harsh, the practices of debt collectors have been deeply concerning. Just last month, the National Consumer Law Center stated that debt collectors estimate contacting consumers more than 1 billion times a year, 1 billion times a year. And according to the NCLC, in an appearance before our committee, 71 million Americans, nearly 1 in every 3 Americans, have a debt in collections reported in their credit file. In practice, this is literally ripping apart people's lives. Military service members have been taken to court by payday lenders. Low-income families have had small utility fees turned into excessive debt and lawsuits that impact them for years. One man in my neighboring state of Kansas ended up in jail 3 times because he was unable to pay the growing debt from an unpaid speeding ticket. People in my home state of Missouri have been thrown in jail because they were not able to pay for traffic violations and other minor offenses. Stories such as these go on and on and on. The Stop Debt Collection Abuse Act, which has been endorsed by the National Consumer Law Center and the Center for Responsible Lending, would amend the Fair Debt Collection Practice to apply that statute to collectors of debt owed to the federal agency, protecting consumers from insidious collection practices. The proposal, among other things, would prohibit contact with a debtor after the debtor communicates that they do not wish to be contacted. Furthermore, collectors of any debt owed to a federal agency would be prohibited from collecting any interest, fee, charge, or expense incident to the principal amount of the debt unless the amount collected is, number one, reasonable, number two, authorized by a contract with the debt collector and the federal agency, and number three, not greater than 10% of the amount collected by the debt collector. This bill will close a number of loopholes, including one that allows for abusive practices by debt collectors hired by government agencies and promote fairness and consistency across this industry. I'm so pleased to have this bill before the committee for markup, and I will thank the ranking member again for his work. I know that there are two issues that we were not able to completely resolve in advance of this markup. These issues relate to providing clarity and injunctive relief relative to the Fair Debt Collection Practices Act. This just means allowing a court to rule that an action is a violation of the Fair Debt Collection Practice Act and require that they stop that action. The other issue is related to indexing. This merely pulls up the penalties associated with the violation to match the rate of inflation over time. Right now, I believe the penalty is capped at the 1977 rate. It is my hope that we can together figure out ways in which we can, in a bipartisan manner, work these issues out, and I'm confident that this can, in fact, be done. I would now yield to my colleague and co-lead on the bill, Mr. Hill.
Well, I want to thank, Chairman, your time. I appreciate the opportunity to work with you on our National Security Subcommittee and look forward to many hours together on worthwhile efforts there. And it's a pleasure to have collaborated with you on HR 4403, Stop the Debt Collection Abuse Act. My intent here is this is in the what's good for the goose is good for the gander category of bills that we look at on this committee, which says if we're going to set up fair debt collection practices and we hold the private sector accountable for that, that a federal agency that's got a debt with a consumer should be held to that same standard. So I appreciate Congressman Cleaver working with me on this. This bill was debated in the last Congress. Representative Love and Representative Ellison worked on it together. The bill does date, the original act dates from 1977, so I'm glad you're considering modernizing it, but I agree with the ranking member that some of these things ought to be looked at more holistically. The 2 points you raised, for example, on injunctive relief or indexing the amounts, those are something that affects every aspect of the fair debt collection process. So as we look at these one-off bills, we ought to collaborate if we can't do a wholesale bipartisan reform of the Fair Debt Collection Practices Act. I know the chair of the full committee and the ranking member of the full committee share that view, and I yield back my time.
The gentleman yields back. Is there further discussion on the amendments to HR 4403?
I move to strike last word.
Thank you, member.
I move to strike last word. Look, I'm grateful to see this bipartisan bill. I want to commend my colleague and subcommittee ranking member on national security for working with his counterpart, Mr. Cleaver, in coming up with a good bill. It's not perfect because we're legislating in a bipartisan way. That means that somebody has to be willing to sacrifice some of their equities, and the other person has to do likewise. That is the sticky part of legislating, the difficult part of legislating. And so what we have here is important for consumer protections, including notification requirements and limits on the sale or transfer of consumer debt to a debt collector. That's really important for the average everyday consumer who only has this interaction with people when it's negative, right? And so at the very least, they should know who owns their debt and who they owe debt to. And I think this is a really useful, good bill to that end. And then other issues also I think are important is a GAO study, which will become an important mandate in order to get the GAO to provide us information for future legislating around the government agencies' use of debt collectors. And so it's a great bill, and would encourage my colleagues to vote yes. And I, again, want to commend Mr. Cleaver and Mr. Hill for working this out and doing it in such a fine and bipartisan fashion. With that, I yield back.
To the ranking member, I don't think there's anything that's...
Or I'm happy to yield.
Thank you. Thank you. I don't think there's anything in the recommendation that have been proposed that is exotic and way out there. So I look forward to sitting down and working with you for this important bill. Is there further discussion on...
Yield back.
The gentleman yields back. Is there further discussion of Amendment HR 4403? The gentleman from Virginia.
Mr. Chairman, I have an amendment at the desk.
We'll pause to allow copies of the amendment to be distributed.
So they're asking to merge two bills, the Meeks bill and your bill. So the Meeks bill is the one that has a state, deals with state federal debt issues. The problem is that Schumer has a problem with, has an issue with merging the bills. It's a New York issue. Meeks has agreed not to merge the bills, so you've got to object to this amendment. Okay. Meeks has a problem with the idea of merging the bills.
He wants to leave the amendment off.
Yeah, he wants to leave the amendment off and not merge it because it's a New York state issue.
Okay.
There's other protections that are in Meeks's bill that is not reflected in this amendment.
So we'll just drop it.
Or you have to oppose it. You have to oppose it. Is there anything that we can procedurally just do with the board? How do we vote on that?
I don't think so. I think the FDCPA covers both federal and state, right? This bill deals with federal, but the GAO study is quite broad.
Our study is broad. That's right.
So since it covers both federal and state, I don't think you can knock it out. Urge them to withdraw it. It's another
So,
tactic.
and asking, can we withdraw this and have a conversation as we have a fulsome conversation about the two other provisions that we plan to?
And if not, then you'd have to oppose if he's going to insist on it. Statement first.
Without objection, oh, I'm sorry. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 4403, offered by Mr. Riggleman of Virginia. Page 2, line 7, strike federal agency and insert federal.
Without objection, the amendment will be considered as read. The gentleman from Virginia is recognized for 5 minutes in support of the amendment.
Thank you, Mr. Chairman. I would like to thank the gentleman from Missouri, Mr. Cleaver, and the gentleman from Arkansas, Mr. Hill, for their work on the underlying measure. I think we all know that balancing finances can be difficult for many Americans, and for lack of a better phrase, crap happens, and sometimes debt default is a reality. My amendment is simple and needed. It would extend consumer protections under the Fair Debt Collection Practices Act to those individuals indebted to state and local governments. We should have parity across the board when dealing with debt collection. Consumers should be entitled to the same protections under the FDCPA, regardless of whether a debt collector is collecting on a loan from a private entity, the federal government, or state and local governments. My amendment would address this crucial missing piece within the underlying text. We are considering another bill today that would expand different protections to state and local governments. Passing two bills that extend different consumer protections and have different requirements will only serve to make the entire process of collecting on debt more cumbersome and confusing for all parties involved. We should instead consider a more comprehensive approach to this issue. I urge a yes vote on my amendment and yield back the balance of my time.
Would the gentleman yield?
Yes, sir.
Mr. Riggleman, the gentleman from Virginia, I would ask that you consider withdrawing the amendment and work with the gentleman from New York, Mr. Meeks. There are some New York issues entangled in your amendment that we can't resolve, I don't think, here in this committee room. And so I would ask that you give some consideration to meeting with him and discussing it further. He has already agreed, he's not here now, he's already agreed to sit down with you.
Yeah, if we could, yeah, exactly, on the Meeks bill, if we could talk more about that, I'd really appreciate it. So thank you for that, and I'm happy to withdraw the amendment if we can continue that discussion.
Thank you. The gentleman withdraws, so I will communicate this to Mr. Meeks. He is fully knowledgeable that this is being done. Thank you.
Thank you, Mr. Chairman.
Is there further discussion on of amendments on HR 4403? If not, the question now occurs on approving the amendment in the nature of the substitute. All those in favor say aye. Aye. All those opposed say nay. The amendment, in the opinion of the chair, the ayes have it, and the amendment in the nature of the...
Mr. Chairman, may I ask for the ayes and nays? Oh, I'm sorry. I'll wait.
All those in favor say aye. Those opposed say nay. In the opinion of the chair, the ayes have it, and the amendment in the nature of the substitute is agreed to. The question now occurs on ordering H.R. 4403 as amended to be reported favorably to the House. All those in favor of approving H.R. 4403 as amended, say aye.
Aye.
The opposed, nay.
Mr. Chairman, I ask for the ayes and nays.
A recorded vote has been requested. All those in favor of a recorded vote shall raise their hands and be counted. There is sufficient second and recorded vote, and a recorded vote is now ordered. Pursuant to Section C5 of Rule 3 of the committee rule, the vote on this question is postponed. The chair now calls up H.R. 3490, the Small Business Lending Fairness Act of 2019. The clerk will report the bill.
H.R. 3490, a bill to amend the Truth in Lending Act to prohibit certain unfair credit practices and for other purposes, being enacted by the Senate and House of Representatives of the United States of
Without
America.
objection, the first reading of H.R. 3490 is dispensed with. The gentlewoman from New York, Ms. Velasquez, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance and are on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to H.R. 3490, offered by Ms. Velasquez of New York and Mr. Marshall of Kansas. Strike all after the enacting clause.
Without objection, the amendment in the nature of the substitute will be considered as read and considered base text for purposes of further amendment. I now recognize the gentlewoman from New York for 5 minutes, Ms. Velasquez.
Thank you, Mr. Chairman. When I talk to small business owners, as chair of the House Small Business Committee, one of the first things they mention to me is that access to capital fuels new startups and help existing businesses expand into new markets and grow their customer bases. And we know that when capital is accessible and on fair terms, small businesses can do what they do best, strengthen our communities and fuel our economy. Unfortunately, affordable capital can be hard to come by for many owners. Whether it's a taxi cab driver in New York City pursuing the American dream or a small business owner trying to make payroll, predatory lenders have been targeting individuals and small businesses with loans that have excessively high interest rates and unfair and abusive terms. This is an ongoing problem in many areas of lending. In recent years, many unscrupulous lenders have required borrowers to sign a confession of judgment just to get the money. Because cash flow is so vital to a business survival, many owners feel they have no choice but to sign away their rights to save their businesses and provide for their employees. By signing a confession of judgment, borrowers essentially waive their legal rights regarding any legal dispute that might arise. And if one does arise, the lender can unilaterally declare a default and take action against the small business owner. In doing so, these lenders have hijacked our courts by getting rubber-stamp judgments from county clerks without notice or court hearings. Many times, small business borrowers only find out about a judgment against them after the lender begins to seize bank accounts or other assets. Over the past few years, Lenders have used this instrument to win more than 32,000 judgments in state courts. While confessions of judgments have been banned at the federal level under the Truth in Lending Act for consumers' loans since 1985, these protections have not been extended to commercial loans. That is why I have introduced this bill, H.R. 3490, the Small Business Lending Fairness Act, which will put an end to these predatory collection practices. By ending confessions of judgment in commercial lending, we can stop some of the abuses that are crippling honest small business owners. I find it appalling that my home state of New York was recently made a magnet for dishonest lenders, and I am pleased that in June, state lawmakers effectively eliminated the use of confession of judgments in the small business finance industry, closing a loophole that was exposed last year by a series of Bloomberg Businessweek articles. But this is not enough, which is why passage of this legislation is so critical. As predatory small business lenders continue to evolve and find creative ways around the law, we here in Congress must similarly be proactive in addressing those predatory practices and rooting out abuses that are harming honest, hardworking small business borrowers. Closing this loophole ensures that predatory lenders can no longer use a confession of judgments practice to seize the assets of small firms without due process, and they will be protected when they are looking to obtain a loan. I want to thank Representative Marshall for co-sponsoring this legislation with me in the House, and Senators Brown and Rubio for their work on companion legislation in the Senate. Finally, I want to thank Chair Waters for her support of this bill and for working in coordination with my team on the House Small Business Committee. I urge my colleagues to vote yes on the bill, as a vote for this bill is a vote for America's small businesses. And I ask unanimous consent, Mr. Chairman, that 2 letters of support be entered into the record from Responsible Business Lending Coalition and 1 from Americans for Financial Reform and Other Consumers Group.
Without objection.
Thank you. I yield back.
Is there further discussion of or amendments to H.R. 3490?
Mr. Chairman, I move to strike the last word.
For what purpose does the gentleman from Missouri seek recognition?
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Legislation before us would ban confessions of judgment for all commercial loans in the United States. As many of my colleagues know, a confession of judgment is a written agreement between a borrower and a lender where if the borrower should default, the lender can seek a judgment to obtain funds outside of litigation. Simply put, a confession of judgment is a tool that a lender can use to collect the money they lend. The Federal Trade Commission has prohibited confessions of judgment in consumer loans since 1985, and many states prohibit their use in mortgages. Confessions of judgment are currently available for use in commercial loans. However, like many tools, a COJ can be misused. Congressman Velasquez, home state of New York, had many issues with confessions of judgment in the past, as she's just detailed. Specifically, the issues centered around debt collectors filing confessions of judgment in the state of New York against out-of-state small businesses. In turn, New York passed state laws to deal with this issue. The New York legislation states that if a small business or individual resides in any state outside New York, you cannot file a COJ against them within the state of New York. It is important to note the legislation passed in the state of New York on this issue did not eliminate the use of confessions of judgment altogether. Debtors in the state of New York can still enter confession of judgment agreements. Yet the legislation we're examining today seeks to ban confessions of judgment across all commercial lending, and even worse, seeks to drastically increase CFPB's authority by allowing them to regulate commercial lending. The gentlelady from New York really believes this is an inherent issue with any commercial use of confession of judgment. I'm sure a compromise could be reached that would require a specific disclosure for borrowers or even a prohibition on the smallest of loans. However, this overly broad legislation does not seek to address an issue just to punish an industry. Confessions of judgment have many legitimate uses. Don't take my word for it. Listen to this quote from Brad Hoylman, Democrat, New York State Senator, who chairs the New York State Senate Judiciary Committee, introduced the legislation in the state of New York regarding confessions of judgment, and I quote, "Confessions of judgment are legitimate tools that may facilitate commercial transitions, resolve or avoid litigation, or ensure that government agencies can recover funds on behalf of victims," end quote. It should also be noted that one of the largest users of confessions of judgment is the federal government. Both the EPA and DOJ use them to recover funds. In fact, the Department of Justice used a confession of judgment against Bernie Madoff to recover funds for victims in the wake of a scandal. However, the bill does not prevent the government from the practice, only private industry. This double standard not only is bad policy, it once again confirms the do as I say, not as I do attitude of big government promoters. The real purpose of this legislation is to give the CFPB authority over commercial lending. We should remember the title of the CFPB when examining their statutory obligations. The word consumer is very apparent. Despite the unprecedented authority Dodd-Frank gave the CFPB, it still limited its scope to consumer lending. I see no reason to reverse this standing over a legitimate financial tool used by many. While I agree with my colleague that COJs have been misused in the past, fixing the problem is the answer, as New York State has done, not promulgating overly broad legislation banning them from all commercial lending. With that, Mr. Chairman, I yield back.
Is there further discussion? For what reason does the gentleman from Ohio seek recognition?
I have an amendment at the desk.
We will pause and allow copies of the amendment to be distributed. The clerk will report the amendment.
Substitute for the amendment in the nature of a substitute to H.R. 3490, offered by Mr. Davidson of Ohio. Strike all after the enacting clause and insert the following. Section 1, requirement for confessions of judgment. A, in general, Chapter 2 of the Truth in Lending
Madam
Act.
Chair, I ask unanimous consent to dispense with the reading.
I object.
The clerk will continue to read.
15 U.S. Code 1631, et sect, is amended by adding at the end the following. Section 140B, unfair credit practices. In connection with the extension of credit or creation of debt in or affecting commerce as defined in Section 4 of the Federal Trade Commission Act, 15 U.S. Code 44, including any advance of funds or sales or assignments of future income or receivables that may or may not be credit. No person may take or receive from another person an obligation that constitutes or contains a conjugative or confession of judgment for purposes other than executory process in the state of Louisiana. Warrant of attorney or other waiver of the right to notice and the opportunity to be heard in the event of suit or process thereon unless such other person has received a disclosure describing.
Without objection, I agree to the waiver of the reading.
Without objection, the amendment will be considered as read. The gentleman from Ohio is recognized for 5 minutes in support of the amendment.
Thank you, Madam Chairwoman. I want to thank the gentlewoman from New York for her work on the underlying bill. The bill itself would prohibit the use of a confession of judgment and the similar provisions in all loans, including all extensions of credit, regardless of the nature of the loan or borrower. However, many financial institutions, including our community banks, venture capitalists, angel investors, and others, include confessions of judgment as a tool. In fact, as a small business owner and as an investor, I've participated in such loans. Even the federal government includes confessions of judgments as a standard provision in loan contracts. My substitute amendment would strike the underlying prohibition and instead require that the creditors provide all borrowers with a clear disclosure explaining that the contract contains a confession of judgment provision. It would be explicit, overly explicit, that the person is signing a contract that contains this provision and also communicate what is implied with that provision. My substitute amendment would help small business owners by requiring clear disclosure so that they know exactly what stipulations they are agreeing to upon signing. Instead of banning a widely used product with little or no debate or conversation, we should work in a bipartisan fashion to improve transparency and foster a more responsible credit-based economy. The unintended consequence of a ban will mean that businesses will go less funded. They'll have less access to debt, credit, and they will be forced to take on more expensive equity, capital, and that will raise the cost of capital, raise the cost of goods, create higher barriers to entry for all sorts of small business owners and entrepreneurs. I urge a yes vote on my substitute amendment, and I yield back the balance of my time.
Is there further debate on the amendment?
I strike the last word.
For what purpose does the gentlewoman from New York seek recognition?
Strike the last word.
The gentlewoman is recognized for 5 minutes.
First of all, in 1985, we passed the ban banning the lending, individual lending, consumers lending. Since then, we haven't had difficulty for small businesses to access, for individuals to access capital. The same will be true with this. We have not evidence that shows that since 1985, when we passed that law, that access to capital for individuals has been impacted. But I just would like to ask the gentleman, do you have any specific example of how disclosure has made the borrower better understand and accept the terms of a confession of judgment?
Yeah, I can explain from firsthand.
Does the gentlewoman yield?
Yes, I yield.
I thank the gentlewoman for yielding, and to illustrate this, I signed a cognovit note. And cognovit is a term that refers to a confession of judgment. And although I graduated from the United States Military Academy and have a Master of Business and Administration degree from the University of Notre Dame, I did not know what cognovit meant. So as I was signing a contract without a required...
So what you're telling me, sir, that this, would you, let me reclaim my time.
As a business owner, I signed this kind of agreement.
Reclaiming my time. What it means then, that the disclosure didn't help. You
No,
understand.
the exact opposite.
So
The disclosure is what made it clear to me. You asked me, I gave you an illustration that makes it clear.
The time belongs to
Reclaiming
the
my
gentlewoman.
time, my concern with the disclosure is that, like the confession of judgment itself, it is extremely confusing, and likely that borrower has no idea what is they are signing. And people are so desperate to get a loan that they are willing to sign any disclosure without understanding what they are signing for. This amendment will allow for the continued use of confessions of judgment by merchant cash advance industry. Lenders in this industry go around lending regulations and usury caps by calling what they did merchant cash advances, lending against the future profits of a business and not loans. And let me just say this. Davidson, I introduced this bill in the 115th Congress. I introduced this bill in June. We held a hearing here on financial services. We held a hearing in the Small Business Committee. You are a member of this committee. You never raised any issue related to disclosure to me. And so you have your time. You didn't raise that issue, and I don't believe that by signing a disclosure, it will address the issue that we are trying to address here, how this is going to be used as predatory practices impacting small businesses in our nation.
The gentlelady yield.
I yield.
We've been trying to work on this bill for 2 markups now. We've not had any of our feedback included in this as an alternative course of action. And frankly, when you asked my opinion, you literally tried to tell me that my own words meant the exact opposite of the words I used. I know what they meant because I used them. The disclosure made it more clear because when you're reading a contract, you say, what does this mean? What am I committing to? Here you go over and above that by putting an explicit definition of what a confession of judgment or a cognovit means. It would make it clear this is what you're signing for. And at the end of the day, a commercial lender is expected to be able to say, yeah, I'm entering into a contract, I expect to pay it. We can't have the definition of a fraudulent actor or somebody who expects to be repaid. The ideal that you provide a disclosure should be over and above what is already expected when you enter into a commercial contract. If that weren't the case, the judgments would never be upheld.
Reclaiming my time, I've been speaking to online lenders too, and the lenders from the Responsible Business Lending Coalition, the Innovative Lending Platform Association, all of them support my bill as currently drafted, because they also know that the use of confessions of judgment against small business borrower is predatory. So therefore, I urge the members to vote no on this amendment.
Madam Chair,
For what purpose does the gentleman from Missouri seek recognition?
strike the S word.
The gentleman is recognized for 5 minutes.
Thank you. I just wanted to speak in support of the amendment. I think that the gentleman has really added to the bill here from the standpoint of giving it the transparency that we need to be able to see this. I think that's what he's trying to do. You know, to have a separate disclosure is a good thing. Normally everybody, especially on the other side of the aisle, wants more disclosure, so here we have it, and now we're against it. It's interesting because you know, back in, because I've been around a long time, I remember back in the 80s, you know, we didn't have, we had a separate set of rules for home mortgage lending. The federal government set the interest rate for home mortgages and did not do anything. It was an open negotiated rate on the commercial side. Why? Because they believed that the consumers were not bright enough or couldn't take care of or be able to negotiate their own interest rate, where those people who were in business were considered somebody who was able to understand business, understand how to negotiate, and be able to sit down across from their lender and make that, do that transaction. So in the 80s, they did away with the rate set by the government and believed that the consumers are bright enough to do this, as we found. They are. They're very bright. They understand completely how a mortgage works, how to price it. Disclosures have helped to be able to have transparency so that the consumer does have the ability to understand what the rate means and understand the costs that are incurred with taking out the loan. Here we have the same situation where we have, you know, back in the 80s, the Federal Trade Commission prohibited these confessions of judgment on consumer loans. And now we have it basically just on commercial loans. And why? Because they are, again, in many cases, negotiated types of transactions where the business owner sits down in order to be able to get this loan. There's a lot of things that go on. A commercial loan is a very, very complex document most of the time. And I think the gentleman here, Mr. Davidson, is just trying to add through this that there is some transparency. And I think that this is a good thing. I think being able to see the costs of the loan, to be able to see the risks of taking out the loan, the consequences of not paying, is what's wrong with that? It's, to me, this is good governance, this is good policy, and I believe that with that, I'll certainly yield some time to Mr. Davidson if he'd like to pursue some additional comments on his amendment.
I thank the gentleman for yielding, and I would point out it is a good faith amendment. It is a big compromise for folks on our side of the aisle to say, hey, with this amendment, we would support a massive enlargement of the scope of the CFPB. So, I think that the reflexive way to run the committee seems to be, this is your side of the aisle. We're voting this way. We got the votes. Deal with it. Elections matter. Forget about it. And instead, we could have a more collaborative process. It's a good faith amendment. It's something, as I attested to personally, see the word cognovit used, even with all the advanced education that I had, it was beneficial to have the disclosure of exactly what is meant by that term. And I think many business owners would benefit from the same disclosure. I think it's a great amendment, and I appreciate the gentleman for yielding.
Would the gentleman yield?
Yes, I certainly yield.
So I am open to continue to, he mentioned that he wants to discuss other things. Well, I am willing to discuss other things before this bill gets to the floor. So I am open to that. But disclosure is already in. What we want is to ban confessions of judgment.
Reclaiming my time. I think that's the problem, is that we don't want to ban confessions of judgment. I think a disclosure to indicate what's going on is a great compromise here. The confessions of judgment are something that are used, and what you're trying to do here, in all due respect, is allow the private sector to not do something that the federal government's able to do. That can't happen. We can't have two sets of rules. That's not the way to do business, and I don't think that's what anybody in this place wants to have happen. So
Will you yield?
No, we're not going to.
Tell that to the thousands of people that have been impacted
yielding.
and lost everything because of predatory
I think,
practices.
Time belongs to
with all due respect, New York had its own separate problem. New York solved its problem with legislation. I think that's what needs to happen here, is we have a good piece of legislation there with some challenges, which has some challenges, but if you allow some amendments to go on to improve it, perhaps we can get to a point where we can support it. With that, I yield back the balance of my time.
Is there further debate on the amendment? Is there further debate? If not, the question occurs on the amendment. All those in favor of the amendment say aye.
Aye.
Those opposed, nay.
Nay.
In the opinion of the chair, the nays have it. The nays
Madam Chair, I ask for a recorded vote.
A recorded vote has been requested. All in favor of a recorded vote shall raise their hand and be counted. There is a sufficient second, and a recorded vote is so ordered. Pursuant to Section C5 of Rule 3 of the committee rules, the vote on this question is postponed. Is there further discussion of or amendments to H.R. 3490?
Madam Chair,
For what purpose does the gentleman from North Carolina seek recognition?
I have an amendment at the desk.
We will pause to allow copies of the amendment to be distributed.
They might raise a concern that the last amendment was a substitute and yours is also a substitute. We're working on getting this redone. So we might need to just hang tight for a second. Let them read through the amendment and object to letting them dispense with the reading.
Okay. So,
Do you ask for the objection for the dispense? You ask for the dispensing? Make them read. If they try and dispense with reading, you object, but please don't ask for it. We'll come back to you in just a minute. Okay.
no, I want them to read.
Clerk will report the amendment.
Substitute for the amendment in the nature of a substitute to H.R. 3490, offered by Mr. Budd of North Carolina. Strike all after the enacting clause and insert the following. Section 1, requirement for confessions of judgment. A, in general, Chapter 2 of the Truth in Lending Act, 15 U.S. Code 1631, et sec. Is amended by adding at the end the following. Section 140B, unfair credit practices. In connection with the extension of credit or creation of debt in or affecting commerce, as defined in Section 4 of the Federal Trade Commission Act, 15 U.S. Code 44, including any advance of funds or sale or assignment of future income or receivables that may or may not be credit. No lender may take or receive from another person an obligation that constitutes or contains a cognovit of confession of judgment for purposes other than executory process in the state of Louisiana, warrant of attorney, or other waiver of the right to notice and the opportunity to be heard in the event of suit or process thereon, unless the other person provides to the lender a written affidavit describing the nature of the default and the date on which such default occurred. B.
Madam Chair, I ask for unanimous consent to dispense with the reading of the bill. And I also ask for unanimous consent to modify the amendment in the form that I have placed at the desk.
Without objection, the amendment will be considered as read. Is there an objection to the gentleman's request for unanimous consent? If not, the gentleman from North Carolina is recognized.
Thank you, Madam Chair. I want to start by thanking the gentlewoman from New York for her work on the underlying legislation. I know that she is sincere and this bill comes from a good place. However, I want to raise a few concerns with the text, and I hope that my amendment will be heard by my Democrat colleagues. And I hope that if accepted, this amendment will help us craft a bill that has a legitimate chance of becoming law. Madam Chair, the underlying bill would prohibit the use of confession of judgment provisions in all loan contracts, including all extensions of credit, regardless of the nature of the loan. Many financial institutions, for instance, community banks, and even the federal government, include confessions of judgment as a standard provision in the loan contract. Often, COJs or confessions of judgment are not enforced, but rather they are a tool that many smaller financial institutions, such as community banks, use to protect themselves. So while, yes, there are some bad actors, and I want to go after them, we cannot push a bill so broad that it prevents or prohibits legitimate use of the COJ. The Federal Trade Commission prohibited confessions of judgment in consumer loans in 1985, and many states prohibit their use in mortgages. The bill before us today would extend the prohibition on confessions of judgment clauses to commercial contracts. As I said, many financial institutions include confessions of judgment as a contract term in a commercial loan, but they do not enforce the provision. So, Madam Chair, recouping a loss is necessary for a credit-based economy to function properly, and confessions of judgment are one tool that serious lenders and debt collectors use to collect from delinquent borrowers. So, instead of banning this entirely, let's just find a middle ground. My substitute amendment attempts to do so by requiring lenders to obtain written affidavit claiming or containing the date and the nature of a borrower's default in order to execute a confession of judgment. This will crack down on the misuse of COJs that has been reported, for example, in Bloomberg, while allowing these important repayment tools to remain in place. So I urge my friend on both sides of the aisle to support this amendment because it addresses the problem at hand that the majority is rightfully trying to solve, while at the same time preserving the COJ for financial institutions who use this tool for a very good reason. So again, I appreciate the bill offered by the gentlewoman from New York. And I understand that there has been a problem in her state, and I know that she wants to fix it. I just suggest that this bill as written is not the way forward, and I urge a yes vote on my substitute amendment to help us find the proper way here for our borrowers and for our lenders. With that, I yield back.
For what purpose does the gentlewoman from New York seek recognition?
I move to strike the last word.
The gentlewoman is recognized for 5 minutes.
Mr. Bott, it's a problem not only in New York, because North Carolina, also the state legislature passed legislation banning confessions of judgment. So this is not only in New York. What we're trying to do is to ban this predatory practice so that we could protect the rights of borrowers and especially small businesses. My concern with the signing an affidavit is that, like the confession of judgment itself, it is extremely confusing. Unlikely that borrower has no idea what are they signing. So what we are trying to do here is to eliminate, is to ban confession of judgment for small businesses, borrowers. And signing another document is not going to address the issue of predatory lending that we have witnessed not only in New York, but in your state.
Is the gentlewoman yielding some time? Gentlewoman yield?
Yes.
Yes, thank you. So we're talking here particularly about commercial loans, which means that we're dealing with a more sophisticated borrower. And there's also, there's no threshold to determine whether this is for small businesses or large businesses. So it's missing that threshold. And also I'd want to say that we need to make sure that we are preserving states' rights, which of course New York used with their regulation. And I think rather than broadly saying that North Carolina did this, I think we need to differentiate between consumer loans, which we probably agree on, and the higher sophistication of commercial loans and other businesses. And I yield back.
It's my time, reclaiming my time. Small business loans are consumer loans too. So, as I said before, what we want is to tackle the issue of predatory lending and protecting the rights of small businesses. And I've been open to work with you for months. No one has approached me on any of these issues. And if the gentleman wants to withdraw his amendment and work with me before we go to the floor, we can do that.
Gentlewoman.
Yep, I'll leave the amendment. I will not withdraw the amendment. Thank you.
Well, I will oppose the amendment. I yield back.
The gentlelady
Madam
yields
Chair.
back.
Madam Chair,
For what purpose does the gentleman from Missouri seek recognition?
strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. I just want to speak in support of the amendment. I think this is a good transparency amendment from the standpoint of being able to show that someone has defaulted, how it all took place. There is no hearsay. There's no. I think this keeps a lot of the mistakes out. You know, if there's somebody that somehow the borrower got some people mixed up, somehow they inadvertently didn't apply the payments correctly. You know, whenever you show that this is how the default occurred, it gives the borrower, I think, the ability to show that there was a mistake on the part of the lender. And so I think this, and it also takes some of the arbitrariness out. I know we're trying to look here to see once if this actually, because to me this is a protection. This whole amendment by Mr. Budd here is a protection for the consumer, and I think it's a good protection. We're still trying to figure out here whether this affects federal government or not, because your underlying bill allows, or trying to ban COJs for the private sector, but allow the government to still do this. if this affidavit, this amendment continues to apply to the government as well, I think this would be a fantastic amendment, because I think we need to make sure the government, if you are going to go out here and allow the COJs to continue to exist for the federal government, absolutely, positively needs to be able to prove that a consumer, that a citizen of this country is past due or delinquent. They need to show how that occurred and how their bookkeeping shows that there's something wrong. So,
Will the gentleman yield?
Sure.
So you tell me how this signed affidavit will protect borrowers and will prevent the lender to have the unilateral ability to declare a default, clear out their bank account,
Sure,
and seize their assets, all without the knowledge of the small business borrower.
Well, if,
So
number one, this is a commercial loan that you're talking about, so those
Correct.
folks know, number one, this is a commercial, reclaim my time. Number one, this is a commercial loan you're talking about, so those folks understand what they just signed. They know the risks that they're taking, they know the kind of collateral, they know the kind of security they put up, and the consequences of what they're doing. Number one.
Will you yield?
No, I'm not done explaining to you why your comment is incorrect.
No, it's not incorrect.
Yeah, yes, it is. So that, I think we're, I lost my train of thought. I'll yield back to you, I'll let you continue on, I'll get my train of thought back. How's that?
So will you yield?
Sure,
So you're telling me how the taxi medallions in New York, so they knew that if they defaulted, that the borrower, that the lender will go and seize their account? What happened in North Carolina when they passed this legislation? So because small businesses, they were small businesses, they knew what they were signing?
Yeah, I reclaim my time. Yeah, I think, again, we're not talking about consumers now, we're talking about commercial borrowers. We're talking about business people who have the acumen to be in business, have the acumen to understand documents. If you're a large lender, if you're a large business, you're going to wind up with an attorney going to this closing. So you know what you've got yourself into. So I think an affidavit that specifically says how you defaulted on a loan. This is telling the borrower in detail what happened here, and it's a transparency thing, so that in case the lender messed up, if the lender misappropriated, say they misapplied a payment, or the mail didn't get the payment to them, or there's been a miscommunication of some kind, this would allow the borrower to see that suddenly, whoa, I can show you that I made all my payments. Your document here says I didn't make this payment on such and such a date. Here's my payment. And so they can work this out. This is a transparency thing. This is a way to be able to help each other work through the situation. I don't know why we can't have somebody to actually prove that something happened and show that it's documented, and then that'd be a bad thing. I'm just kind of at a loss here. Be glad to yield back yield some time to the lady if she'd like to continue on with the discussion here.
Well, my position is, we conducted hearings in this committee, hearings in my small business committee. You have never raised these issues.
Okay.
But
Okay.
beyond that, I'm willing to sit down with you and
Okay,
discuss.
I will reclaim my time.
I will.
Again, I think I understand the lady's concern with regards to New York and perhaps North Carolina, but those issues were solved by state legislatures who actually went in and fixed the problem. I think let's don't throw the baby out with
It's
the bathwater.
happening everywhere, not only in North Carolina or New York.
I yield back.
Is there any further debate on the amendment? Is there any further debate on the amendment? If not, the question occurs on the amendment. All those in favor of the amendment say aye. Aye. All those opposed, nay.
No.
In the
Madam
opinion
Chair, I
that-
ask for a recorded vote.
I'm supposed to flip the page now. A recorded vote has been requested. All in favor of recorded vote shall raise their hand and be counted.
Only three.
There is a sufficient second, and recorded vote is so ordered. Pursuant to Section C5 of Rule 3 of this committee, the vote on this question is postponed. Is there further discussion of or amendments to HR 3490? Any more discussion? If there are no further amendments without objection, the previous question is ordered on HR 3490, and further proceedings on recorded votes are postponed. The chair now calls up HR 5001, the Non-Judicial Foreclosure Debt Collection Clarification Act. The clerk will report the bill.
HR 5001, a bill to amend the Fair Debt Collection Practices Act.
I got that, man.
To clarify that the definition of a debt collector includes, in all cases, a person in a business, the principal purpose of which is the enforcement of security interests.
Without objection, the first reading of HR 5001 is dispensed with. The gentleman from Missouri, Mr. Clay, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance or on the days.
Madam Chair, I move for the adoption of the amendment.
The clerk will read the amendment.
Amendment in the nature of a substitute to HR 5001, offered by Mr. Clay of Missouri. Strike all after the enacting clause and insert the following. Section 1, short title. This act may be cited as the non-judicial foreclosure.
Without objection, the amendment in the nature of a substitute will be considered as read and considered base for text for purposes of further amendment. I now recognize the gentleman from Missouri for 5 minutes to explain the bill and his amendment.
Thank you so much, Madam Chair. And HR 5001, the Non-Judicial Foreclosure Debt Collection Clarification Act, merely clarifies that entities in non-judicial foreclosure proceedings are covered by the Fair Debt Collection Practices Act. Congress enacted the FDCPA in 1977 to eliminate abusive debt collection practices by debt collectors by rendering particular types of collection activities as unlawful. We arrived here via a Supreme Court case, Obdusky versus McCarthy and Holthus, which held that a business engaged in no more than non-judicial foreclosure proceedings is not a debt collector under the FDCPA. And a little bit of background on the case: Dennis Obdusky, a Colorado resident, bought a home in 2007, which you'll recall was at the height of the foreclosure crisis, with a loan for $329,000 that was secured by the home. In 2014, Wells Fargo Bank hired the McCarthy law firm to foreclose on Mr. Obdusky's home via a non-judicial foreclosure, a procedure used in many states where notice and sale of the property occur outside of court supervision and oversight. Obdusky responded with a letter invoking Section 1692 GB of the FDCPA, which provides that if a consumer disputes the amount of a debt collector must cease collection until it obtains verification of the debt and mails a copy to the debtor. In other words, Mr. Obdusky simply asked the law firm for proof that he owed the debt, a firm which had initiated numerous foreclosures on behalf of Wells Fargo and other banks, yet instead they proceeded with the foreclosure. And let me remind my colleagues that, as the National Consumer Law Center noted in its amicus brief for the case, foreclosures are costly for homeowners, investors, the government, and most importantly, communities. And that is why the law requires strict vigilance to timelines, deadlines, and other procedural matters. Yes, the Supreme Court held that under certain conditions, the full range of FDCPA prohibitions do not apply to collection attorneys when they implement the steps required to conduct a non-judicial foreclosure. And that is because, with limited exceptions, the FDCPA applies only to entities that qualify as debt collectors. The statute's definition of debt collector is intricate and excludes various entities from its scope. At the end of the case, Justice Sotomayor's concurring opinion invites Congress to weigh in to clarify its intent. A simple amendment to the final sentence of the FDCPA's definition of debt collector to clarify that the terms does not exclude those who conduct non-judicial foreclosure of home mortgages would fix the problem. And action by this bill would provide needed protections for homeowners and reinforce the consumer protection mandate that the statute intends. And I encourage my colleagues to support this important consumer protection measure, and I yield back.
For what purpose does the gentleman from North Carolina seek
Move to strike the
recognition?
last word.
The gentleman is recognized for 5 minutes.
Thank you, Madam Chair. I appreciate the gentleman from Missouri, Mr. Clay's good work and good intention on this bill and his concerns about consumers impacted by foreclosure and especially non-judicial foreclosure regimes. But I oppose the bill. This bill is little more than an attempt to overturn the Supreme Court's March 2019 decision that was a 9-0 decision written by Justice Breyer, which upheld state non-judicial foreclosure statutes and ruled that persons enforcing security interests are not subject to the same requirements as debt collectors. And so 31 states in the District of Columbia have non-judicial foreclosure statutes, and the states do a good job of regulating this. They're on the front lines of delivering, and if we wish to change these important laws, we should go back to the state legislatures and work through them at the state legislative level. Those 31 states that have non-judicial foreclosure statutes, including my home state in North Carolina, and the gentleman's home state of Missouri, have well-functioning marketplaces and have massive consumer protection. You also have state judges that have upheld these laws in our various states, and they're all similar but different in modest ways from one another. And these statutes all set out basic notification and process requirements associated with the enforcement of a security interest. So this legislation is a little more than an attempt to nationalize these rules, that the states are doing a really good job of regulating themselves, and overturn what is a unanimous U.S. Supreme Court decision. So even in a divided Washington, I think those things still matter. And on this one, we can just agree to disagree on this. I don't think there's any way to sort of modestly go about the legislation that the gentleman's proposing. It is, though a short bill, it is massive in its impact, and I think negative in its impact on states like mine that, as a result of have better mortgage marketplaces because we have important laws on the regulation of how to deal with those mortgages if people aren't paying. So with that, I would urge my colleagues to vote no, and yield back the balance of my time.
Is there further discussion of or amendments to HR 5001?
What's that? I'm sorry.
Is there any further discussion?
Madam Chair.
For what purpose does the gentleman from Georgia seek recognition?
To yield to, strike the last word and yield to Mr. Kelly.
The gentleman is recognized for 5 minutes.
I want to thank my friend from Georgia for yielding. Also, I wanted to kind of take note of what my friend from North Carolina said, and I heard him loud and clear talk about how this should be left up to the states to protect consumers, and I just, and he's right. I don't agree with that. I really don't. And I think that as far as we here in this body are concerned, we should err on the side of doing everything possible to protect consumers, to prevent those scenarios like what Mr. Abdowski went through when he eventually was foreclosed on by a law firm who was representing Wells Fargo, who lost his house when he was asking for what I considered to be reasonable information. Was he under foreclosure? He never got notification properly, and he was pursued and hunted down by this law firm, and he eventually lost his house. And we know what the ramifications and effects are of foreclosing our homes. Believe you me, my district has experienced firsthand by the devastation occurring around foreclosures to neighborhoods throughout the communities that I represent. You foreclose on one or two homes on a block, on one block, and you have the potential to devastate an entire block or neighborhood because you leave the other homeowners out there to fend on their own and to watch their property values drop because the banks don't take care of those foreclosed properties, especially if they're in communities of color. They don't give as much attention to those properties that they still own, that are still part of their portfolio. And so I was just hoping that my friends from North Carolina and his colleagues on that side would try to find common ground on this legislation to try to come to some reasonable understanding of how we come together, how we join together to help consumers. And I will yield back I'll yield back to my friend from Georgia unless my friend from North Carolina wants to engage.
The gentleman from Georgia, it is your time.
I yield back to balance of my time.
The gentleman yields back. Is there a further discussion of our amendments to HR 5001? If not, the question now occurs on approving the amendment in the nature of a substitute. All those in favor say aye. Those opposed say nay. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on ordering HR 5001 is amended to be reported favorably back to the House. All those in favor of approving HR 5001 is amended say aye. Those opposed say nay.
No.
In the opinion of the chair, the ayes have
Ask
it,
for a
and
recorded
HR 5001 is
Ask for a
amended as
recorded vote.
reported favorably, not favorably to the House, and we will have a recorded vote as requested. All those in favor of recorded vote shall raise their hand and be counted. There is sufficient second and a recorded vote is ordered. Pursuant to Section C5 of Rule 3 of the committee rules, the vote on this question is postponed. The chair now calls up HR 5013, the Small Business Fair Debt Collection Protection Act. The clerk will report the bill.
HR 5013, a bill to apply Fair Debt Collection Practices Act to small businesses to the same extent as such act applies to consumers, to require the Director of the Bureau of Consumer Financial Protection to define small business for purposes of such act and for other purposes.
Without objection, the first reading of without objection, the first reading of HR 5013 is dispensed with. The gentleman from Florida, Mr. Larson, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance and are on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to HR 5013, offered by Mr. Lawson of Florida. Strike all after the enacting clause and insert the following. Section 1, short title. This act may be cited as the Small Business Fair
Without
Debt
objection,
Collection.
the amendment in the nature of a substitute will be considered as read and considered base text for purposes of further amendment. I now recognize the gentleman from Florida for 5 minutes to explain the bill and his amendment.
Thank you, Madam Chair. HR 5013, the Small Business Fair Debt Collection Protection Act, will protect small businesses from the harassment of third-party debt collectors. The bill will extend to small businesses protection already guaranteed to consumers under the Fair Debt Collection Practices Act. Simply put, this bill provides the same protection to small businesses that consumers have. Small business is the backbone of our economy. With over 30 million small businesses across the United States, it's imperative that we protect them from harassing debt practices by unscrupulous debt collectors. The bill is supported by the Mainstream Alliance, Responsible Business Lenders Coalition, and the Small Business Majority. I thank my colleagues, Mr. Cleveland, for co-sponsoring this bill, and I urge my colleagues on this committee to pass this good bill to help our small business community. With that, I yield back.
The gentleman yields back. Is there further discussion or amendments to HR 5013?
Madam Chair.
For what purpose does the gentleman from Missouri seek recognition?
I move strike last word.
The gentleman is recognized for 5 minutes.
Thank you, Madam Chair. This before us would give the CFPB authority over small business debt collection practices. It would expand CFPB's authority to the debt collection practices for any of the 28 million small businesses across the United States. It would appear my colleagues on this side of the aisle have once again forgotten the first word of the CFPB, consumer. While Dodd-Frank gave the CFPB incredible power, it still limited scope to consumer products. While this legislation deals with debt collection, a major theme of this markup is that CFPB should have more authority over all commercial financial products. I cannot overstate how disastrous this could be. Commercial financial products are already forced to follow numerous laws and rules, including the Equal Opportunity Act, providing the CFPB with more authority in this space, while there remains little to no congressional oversight of the CFPB, would place the health of commercial lending in the United States in hands of one person. This cannot happen. Going back to the specifics of this legislation, I served with a gentleman from Florida on the Small Business Committee last Congress, so I understand where the gentleman's coming from with this bill. However, I'm very troubled with the practicality of this legislation. Specifically, I'm concerned about this legislation which doesn't even provide a specific definition of small business. Instead, this legislation leaves the definition open for interpretation by a CFPB with consultation from the SBA. I'm sure the gentleman is aware of this, but there is no simple definition of small business. In fact, when I was served with him on the committee, we saw this all the time. The SBA continually publishes a 49-page table that identifies what classifies as a small business for every industry sector of the United States. For example, the size standard for soybean farming is below $1 million in annual receipts, but for family clothing stores, it is over 16 million annual receipts. For a logging company, the measurement is not in annual receipts, but in the number of employees. While it is under 500 employees for logging, it is below 1,500 employees for gold ore mining. These listings go on and on for page after page in the SBA table of small business standards. With roughly 28 million small businesses in the United States and hundreds of size standards for small businesses, I am uncertain as to how the CFPB will be able to accomplish this task and how Congress can ensure the Bureau is doing it correctly. Can you imagine the oversight? Can you imagine the number of people we're going to have to employ? It's full employment. We've already got full employment, right? While I did not support Dodd-Frank, I do agree with the members in the committee who did that it is bad policy to give the CFPB authority over commercial entities. Therefore, I do not believe we should broaden CFPB's scope of authority into commercial lending or allow them to get into defining small businesses that they have no expertise and no understanding of at all. That, coupled with the fact that directives in this bill are impractical, causes me to oppose the legislation, urge my colleagues to do as well. With that, Madam Chair, I yield back.
Gentleman yields back. For what purpose? For what purpose does the gentlewoman from New York seek recognition?
To strike the last word.
The gentlewoman is recognized for 5 minutes.
Thank you, Madam Chair. I would like to thank Representative Lawson for his work on this legislation, which will amend the FDCPA to protect small businesses that are being preyed upon by predatory debt collectors. Earlier this year, the committee held a hearing on abusive debt collectors, and we heard the troubling lack of financial rights and protections for small businesses. A small business with one or a small number of people working for a business is treated for all intents and purposes under the law as if they were a large corporation with an army of attorneys ready to renegotiate debts that are owed. By expanding FDCPA's protection to cover small business loans, this bill helps small businesses that are not major corporations with an army of lawyers or a finance division that can renegotiate debts. Furthermore, the committee heard testimony regarding how taxi cab drivers were considered a small business under the law and not afforded the same protection consumers have under FDCPA. I want to thank Mr. Larson for working with me on the definition of small business to make this bill compatible with SBA 7A and 504 lending programs and other legislation we are currently working on. So I urge my colleagues to support this bill, and I yield back the balance of my time. Mr. Larson, would you like some time?
Thank you. Thank you, Madam Chair. Thanks for yielding the time. I just wanted to clarify that this amendment increases the small dollar threshold from $1 million to $5 million to be assigned to coincide with this small SBA members. I was proud to work with the chairwoman at the Small Business Committee on this threshold. I would tell the gentleman that this is a nonpartisan issue that should be that been supported by all business organizations, especially those that represent the 30 million small businesses out there, to get some clarity and to stop the harassment, especially for small business of women and businesses of color. So I would urge my colleagues to realize that this has been worked out, and I was fortunate to serve on the Small Business Committee with my colleagues, and this was one of the issues that was springing up time and time again, and we feel that our small businesses should have the same consumer protection as anyone else, and I would urge my colleagues to support this amendment. With that, I yield back, Madam Chair.
I yield back.
The gentleman,
Madam Chair.
Mr., for what purpose does the gentleman from Arkansas seek recognition?
Strike the last word.
The gentleman is recognized for 5 minutes.
I yield some time to my friend from Missouri.
Thank you, gentleman from Arkansas. And again, I want to commend my good friend from Florida for his efforts here. But I really don't think we need the CFPB into commercial lending, and especially whenever to have them start helping the SBA define what a small business is. And one of the problems that I also have with what's going on here is that I don't see in the bill, maybe I need to have somebody read it back to me, but I don't see in the bill that the gentleman from Florida is working on here, he's trying to change the Fair Debt Collection Protection Act the way it's drafted and sets now to apply to a small business. Well, let me just go down the list of things here that are concerning from the standpoint that there's some consumer protections in here that really would kind of be inappropriate for commercial transactions. They specifically say that consumers can only be contacted at specific times of day, specific places where they can be contacted, specific individuals who can be contacted and who cannot be contacted when you're discussing debts. So who would that be with regards to a small business or another entity here? Is it going to be the president? Is it going to be the general manager? Is it going to be COO, CFO? If you can only contact people at certain times of the day, does this mean you can only contact the people when they're having business hours? Is that what the problem is? I mean, it really opens up a whole can of worms. Also, the FDCPA rules have no application at all in the context of business debt. I mean, they're not there for business debt. Then that's just, it's kind of like they're almost trying to put a square peg in a round hole. For example, the debt collector is prohibited from contacting consumer at the consumer's place of employment if the debt collector knows knows or has reason to know that the consumer's employer prohibits the consumer from receiving communication. So how do you rationalize those two? That means you can't go talk to the small business owner at his own place of business? Is that what that means? Again, I think we're trying to put a square peg in a round hole. I don't think, while the intention is good here to try and find some relief for some small businesses, I don't think the appropriate place is to empower the CFPB to do this. I think that they've got enough to do already. They don't have any expertise in the small business lending space. I've been an advocate for a long, long time of the government not being in direct lending, so I don't think they need to be in overseeing direct lending when they have no expertise in direct lending as well. We have them already with the FDIC and the Federal Reserve and the Comptroller and all those folks, and the CFPB has some oversight, but I don't think they have any oversight over small business. They shouldn't be in the business. They have no expertise. And so that, I'll yield back my time to Mr. Hill and thank him for his help.
The gentleman yields.
And I yield back to the chair.
Madam Speaker.
For what purpose does the gentleman from Georgia seek recognition?
Strike the last word.
The gentleman is recognized for 5 minutes.
I hate to really get into this love nest between Mr. Lawson and my good friend from Missouri, but I must. As a small business owner, let me just ask the gentleman from Missouri, shouldn't I have the same protection that individual consumers have? And I believe that's all Mr. Lawson is offering here. I think someone earlier said, look at the word, some of us must be missing the first word of the Consumer Financial Protection Agency, which is consumer. I'm a small business owner. Am I not a consumer? And should not I have the same federal protection as any other consumer? I think, Mr. Lawson, isn't that all you're asking? And as a matter of fact, to your point about giving all this to the CFPB, Mr. Lawson's bill clearly points out that what he's offering the CFP to do will be done in consultation with the Small Business Administration. So I just want to share that with my good dear friend and ask him to support Mr. Lawson. Is that possible with my expert explanation as a small business owner?
You mean some time?
Does the gentleman yield time to?
Yes, I yield
Okay,
time.
thank you. Well, I appreciate the conversation, and I understand your point, and I think if some small businesses are intent and they need some protections, maybe there's a way to do that, but I don't think using the same law that protects consumers should be the one that protects small businesses, because there's a difference. A consumer is someone who goes out and purchases things and goes into debt for his own personal benefit. Yes. A business is a completely different entity. I mean, there's a whole set of laws that deal with businesses versus private individuals, and this is a set of them right here that is completely different. So I understand where you're coming from. I don't disagree that perhaps there may be some protections that we can put in place, but let's talk about those protections. Let's don't try and put a square peg in a round hole. You're trying to put private protections on a commercial enterprise, and I just don't think that's the place for it, number one, with CFPB, and number two, I don't think the SBA should be tuned out of this. They're the ones who should be taking care of this business if there's a problem. They should be empowered to oversee this if you're going to do anything at all.
Yeah, let me yield the balance of my time to Mr. Lawson.
The gentleman yields.
Thank you, Madam Chair, and thanks for yielding the time. It's one thing after being in business for 36 years, especially as a small business owner before I came here. Small businesses face a lot of obstacles in terms of resources that they have and some of the harassment that comes from these predatory, like I would say, collectors, especially among women and business members of color. This is one of those issues that transcends party affiliations all over America when you talk about some 30 million. And really, the bottom line is that we need to protect the small businesses from this harassment and debt call. I can tell you that I've seen it on a regular basis over the years. And one of the things that happened here in Congress is that everyone has opinions. When it comes down to the time that we spend with small business, or those on the other side of the aisle who have been involved with small business, they clearly understand most of these small business owners are not even incorporated. You know, they use a Social Security number, or they might have an IRS number for their businesses. But when they go to the bank most of the time, some of the people don't really look at them. I know my time is running out. As nothing but a consumer, and not just a small business. But they're small business that have been the backbone of America, and that's what it is today. With that, Madam Chair, I urge them to support this bill, and I yield back.
Gentleman yields back. Is there any further discussion of or amendments on HR 5013? Is there, if not, now occurs on approving the amendment in the nature of a substitute. All those in favor say aye. Those opposed say nay. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on HR 5013 as amended to be reported favorably to the House. All those in favor of approving HR 5013 as amended say aye. Those opposed say nay. Nay. In the opinion of the chair, the ayes have it, and HR 5013 as amended is reported favorably to the House.
Madam Chair, I ask for a recorded vote.
A recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. There is sufficient second, and a recorded vote is ordered. Pursuant to Section C5 of Rule 3 of the committee rules, the vote on this question is postponed. The chair now calls up H.R. 3948, the Debt Collection Practices Harmonization Act of 2019. The clerk will report the bill.
H.R. 3948, a bill to amend the Fair Debt Collection Practices Act to extend the provisions of that act to cover a debt collector who is collecting debt owed to a state or local government to index award amounts under such act for inflation, to provide for civil injunctive relief for violations of such act and for other purposes. Be it enacted
Without
by
objection, the first reading of H.R. 3948 is dispensed with. The gentleman from New York, Mr. Meeks, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance and are on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to H.R. 3948, offered by Mr. Meeks of New York. Strike all after the enacting clause and insert the following. Section 1, short title. This act may be cited as the Debt Collection Practices Harmonization Act. Section 2.
Without objection, the amendment in the nature of a substitute will be considered as read and considered base text for purposes of further amendment. I now recognize the gentleman from New York for 5 minutes to explain the bill and his amendment.
Thank you, Madam Chair. And thank you for taking up my bill to H.R. 3948 at today's markup. This bill is very simple, really, and it calls for harmonization of consumer protection rights so that any attempts at collection by a state and local governments are consistent with those debts owed to private creditors. Specifically, the bill does the following. Number one, this bill does not prevent state or local governments from collecting money owed but rather ensures that consumers benefit from FDCPA consumer protections, which have historically had broad bipartisan support in Congress. The basic consumer protections include protection from harassment from debt collectors, contact at unreasonable hours or in unreasonable manners, and allows consumers means to push back on inappropriate actions by debt collectors. 2, the legislation calls for inflation adjustment of statutory damages. Statutory damages in FDCPA were capped up to $1,000. While this may have been a material penalty at the time of the passage, this is no longer a credible deterrent to debt collectors who might violate FDCPA. Inflation adjustment of penalties is not unusual or exceptional. Indeed, the Federal Civil Penalties Inflation Adjustment Act of 1990 calls for regular adjustment for inflation of civil monetary penalties so as to maintain the deterrent effect of civil monetary penalties and promote compliance with the law. Yet the penalties for FDCPA have not been adjusted since 1978. 1978. The bill allows courts, this is the third thing, to award appropriate injunctive relief to Americans who pursue civil action for FDCPA violations. Very important. And finally, the bill also addresses a real issue related to collections by FEMA. When Hurricane Sandy hit New York and devastated various districts, and of course including mine, along with many others, FEMA made assistance overpayments to many Americans, including those in the 5th Congressional District of New York. These overpayments occurred entirely as a result of a FEMA error and not of fraudulent actions by the beneficiaries. Years later, FEMA contracted with aggressive debt collectors who harassed and pursued average Americans who just did not understand why or how this came about. They thought that what they received was what they were supposed to receive and that they were entitled to. They did nothing fraudulent. They committed no bad acts. There was no reason for them to know otherwise. They just did what they thought to help them rebuild their homes. And while this problem was eventually resolved by Congress in the FEMA appropriation, it caused significant hardship for impacted families and forced the deep distrust of the government agency tasked with supporting Americans in times of natural disasters. HR 3948 prevents FEMA from contracting with debt collectors to recoup money in the event of overpayment of assistance. Please note, however, that my amendment in the nature of a substitute to the bill creates an explicit exemption for situations where that such overpayment occurs as a result of fraud, or deceit. So if someone is giving fraudulent information or they've tried to deceive or something of that nature, we do not want them to be wrongly enriched. What we're trying to do is to help those individuals who were already devastated and who basically just trusted that FEMA did the right thing and they received the funds they needed to restore their lives. And then they find out later that FEMA made a mistake on its own, and then FEMA used these aggressive debt collectors that then puts these individuals who put the money back into their house, by the way, and now they're saying you owe all of this money. A doubly hit. No fraud, no deceit. Did not know and shouldn't and could not have known that there was an overpayment in that regards. So this fixes that so that we can make sure that ordinary Americans are not doubly harmed in that regards and harassed by debt collectors. I yield back.
Gentleman yields back. Is there further discussion of or amendments to H.R. 3948? For what purpose does the gentleman from Washington seek Wisconsin? It looked like an A, I'm sorry. Seek recognition.
We got snow in Wisconsin. Madam Chair, I speak I speak to strike the last word.
Okay.
I move to strike the last word. You got me thrown from Washington.
I was confused about your state, you're confused about your motion.
No.
All is fair. The gentleman recognized for 5 minutes.
The bill we're discussing here seeks to extend the protections offered to consumers in debt to private lenders, to those who are in debt to state or local governments. Committee Republicans, I think, generally support the underlying premise of the bill. There's no reason to have contradictory consumer protection regimes in the debt collection industry. But I'm puzzled that we're considering two bills that take very different approaches to solving what seems to essentially be the same underlying problem. As I understand it, the bill offered by the gentleman from New York seeks to achieve the same objective as the bill offered by Mr. Cleaver and Mr. Hill earlier. The legislation, however, contains provisions beyond what was included in the bipartisan Cleaver-Hill bill, which garnered the bipartisan and bicameral support that I think is so essential. This legislation, I think, makes an adjustment. If we want to address subjects like monetary awards, injunctive relief under the Fair Debt Collections Practices Act, and overpayments under the Stafford Act, we should do so after careful consideration and debate. The application of the FDCPA to government debt collection, I think, should be uniform. It would be prudent and more efficient to instead consider a bill that sets consistent requirements for collection of debt owed to state, local, and federal governments. While there are provisions of this bill that I and likely others on this side support, I'm concerned this bill takes a more extreme approach that fails to take in the bipartisan Cleaver-Hill bill. I hope committee Democrats will work with Republicans to comprehensively and uniformly address this important issue and reluctantly urge a no vote on this legislation. I yield back the balance of my time.
For what purpose does the gentleman from California seek recognition?
Georgia, strike the last word.
The gentleman is recognized for 5 minutes.
I recognize my time for Mr. Meeks.
Thank you, Mr. Scott, for yielding. Let me just say, there's a couple of things that are extremely important that must continue. When you talk about the statutory amount of up to $1,000 that was created in 1978, which is basically now, there's no incentives for any debt collector to abide by the rule. This is not covered in Mr. Cleaver's bill, and I'm willing to work with, and I'm talking to Mr. Cleaver's office about working with him on federal debts, and I'm happy to work to address those concerns with him when these bills move to the floor. But we think that's significant, and we think that's important. We also believe that it is important for the injunctive relief that the bill allows courts to award to Americans who pursue civil action for FDCPA violations, which is also not included in the other bill. So this bill has much more than, and you're correct in that, but it's specifically to cover areas that have been missed and to make sure that we're protecting those who happen to be collecting from debt collectors. We're trying to collect debts for state and local municipalities. But clearly, we are working with Mr. Cleaver, and we think that we're going to get those things worked out when we get on the floor so that the more inclusive bill would be there. And so we would hope that we could still move with this in a bipartisan manner, because I don't think it's inconsistent with the spirit of what we move and how we've been moving this legislation in the past. And I yield back to Mr.
Gentleman yields back. The time belongs to the gentleman from Georgia.
Back to the gentleman from, to Mr. Scott, to the gentleman from Georgia.
And I yield back. Anybody else want any?
Gentleman from Georgia yields back. Is there further discussion of amendments to HR 3948? If not, the question now occurs on approving the amendment in the nature of a substitute. All those in favor say aye.
Aye.
Aye. All those opposed say nay. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on question now occurs on ordering HR 3948 as amendment to be reported favorably to the House. All those in favor of approving HR 3948 as amended, say aye.
Aye.
All those opposed, nay. In the opinion of the chair, the ayes have it, and HR 3948 as amended is to report it favorably to the House. A recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. There is a sufficient second, and a recorded vote is ordered. Pursuant to Section C5 of Rule 3 of the committee rules, the vote on this question is postponed. The chair now calls up H.R. 5021, the Ending Debt Collection Harassment Act of 2019. The clerk will report the bill.
H.R. 5021, a bill to amend the Consumer Financial Protection Act of 2010 and the Fair Debt Collection Practices Act, improve consumer protections relating to debt collection practices and for other purposes. Be it enacted by the Senate and House of Representatives of the United States.
Without objection, the first reading of H.R. 5021 is dispensed with. The gentlewoman from Massachusetts, Ms. Presley, the sponsor of the bill, is an amendment in the nature of a substitute, copies of which have been distributed in advance and are on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to H.R. 5021, offered by Ms. Presley of Massachusetts. Strike all after the enacting clause and insert the following. Section 1, short title. This act may be cited as the Ending Debt Collection Harassment Act of 2019. Section 2, consumer protections.
Without objection, the amendment in the nature of a substitute will be considered as read and considered base text for purposes of further amendments. I now recognize the gentlewoman from Massachusetts for 5 minutes to explain the bill and her amendment.
Thank you, Madam Chair. Earlier this fall, our committee held a hearing to consider legislation that would protect consumers and small businesses from abusive debt collection practices. I shared what is the story of millions of families taking pride in paying bills on time, just to be sidelined by an illness or a job loss, working harder and harder, but no matter how hard they work, continuing to owe everybody, the utility company, the landlord, the bank, everybody. Feelings of shame, judgment, and vulnerability were reinforced by unceasing collectors hell-bent on recouping debt they purchased for pennies on the dollar. Last month, we had the opportunity to hear from CFPB Director Kraninger on a host of issues, including the agency's proposed debt collection rule. I, along with the chairwoman and Rep. Porter, have made our concerns about this proposed rule well known. In my exchanges with the director, it became clear that we could not reasonably depend on the CFPB to produce a rule informed by and concerned with those most impacted, everyday working Americans and families being pushed further into despair. In lieu of agency rulemaking that actually protects consumers from abusive debt collection practices, I introduced the Ending Debt Collection Harassment Act, legislation to restrict collectors from weaponizing new forms of communication and ensures that consumers have all the information they are entitled to. Specifically, my bill would prevent debt collectors from harassing consumers with unlimited electronic communication, including texts and emails. Additionally, it requires that debt collectors provide consumers with clear disclosures of their rights and a simple way of opting out of electronic communication. Finally, this bill improves reporting on consumer complaints against debt collectors by requiring a state-by-state breakdown of complaints and additional data, specifically on the use of electronic communication in harassing consumers. This common-sense legislation has the support of the National Consumer Law Center on behalf of its low-income clients, Americans for Financial Reform, as well as the National Association of Consumer Advocates and the Center for Responsible Lending. I also want to thank the many colleagues, Rep. Meeks, Cleaver, Tlaib, Ocasio-Cortez, Lynch, Adams, Garcia, and Foster, who have already supported this important bill. In a world where folks are priced out of the most basic goods and services, no one should be forced to live with constant harassment because they simply cannot afford otherwise. I urge the remainder of my colleagues to support this bill, and I yield back.
Gentleman yields back. Is there further discussion of or amendments to H.R. 5021?
Gentleman from Ohio.
Madam Chair?
For what purpose? Purposes, the gentleman from Ohio seek recognition.
Madam Chair, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Madam Chair. This bill is a clear attempt to undermine the CFPB's new proposed rule to modernize debt collection. The bill would prohibit collectors from contacting consumers via email or text without prior consent. It blocks the CFPB from issuing a final rule allowing debt collectors to send emails and text messages to consumers. Director Kreninger's proposed rule attempts to give debt collectors clear rules of the road of how they can utilize modern communications technology. By the way, when this rule was originated, there was no such thing as email or cell phones. So it's natural that they are not referenced today, but the CFPB is working to modernize this and create rules of the road to make sure that these debt collectors do actually know what they can and can't do. My friends on the other side of the aisle, I think, fail to mention that the proposed rule allows consumers the ability to opt out of specific means of communications that are being used by debt collectors, including opting out of text messages or emails. So that's already in the proposed rule. Let's think about it. The Debt Collection Act, enacted in 1977, hasn't been updated as technology has been updated. I already explained that email and cell phones essentially didn't exist in 1977, at least not in a widespread way. And U.S. mail was basically the means of communication and people's landline phones. So it's important that we update the means of communication to recognize the modern world. But it is also important that we create rules of the road. As I said, the proposed rule already allows for an opt-out for consumers. We should let the CFPB do their job and actually put this rule into effect. Separately, this bill requires the CFPB director to analyze and report annually to Congress on the impact of electronic communications utilized by debt collectors. The bill also requires the director to include in its semi-annual report to Congress an analysis of consumer complaints relating to debt collection and enforcement actions taken by debt collectors. We already know, based on public data from the CFPB's complaint database, that debt collection is one of the top complaints by consumers. The consumer complaint database is public, and anyone can actually get that information on the CFPB website today. Moreover, the CFPB, in consultation with the FTC, already produces an annual oversight report of debt collection, which includes data on consumer complaints, enforcement actions taken against those debt collectors. So the reports and information sought by this bill would be duplicative and divert resources that could be used for very important consumer complaints. So I would urge a no vote on this bill, and I yield back the balance of my time.
The gentleman yields back. For what purpose does the gentlewoman from North Carolina seek recognition?
I move to strike the last word.
The gentlewoman is recognized for 5 minutes.
Thank you, Madam Chair. I rise today to encourage my colleagues to support H.R. 5021, the Ending Debt Collection Harassment Act. 1 in 3 Americans say that they were contacted by a debt collector during the last year. According to the CFPB, debt collection is the second most complained about consumer product, accounting for 27% of complaints. And while technology has made communication easier, it's important to safeguard consumers from abuses of that technology without compromising their ability to choose. Congresswoman Presley's bill does just that. Consumers can consent to contact via electronic communication, while their ability to opt out is strengthened as well. I do commend Representative Presley for her work to address the harmful collection practices utilized by some debt collection entities. This bill prevents collectors from harassing consumers via electronic communications, like sending unlimited emails or texts. It also requires collectors to provide consumers with clear disclosures and an easy way of opting out. And it improves reporting around debt collection, consumer complaints, and enforcement actions. Consumers have a right to choose when and how they're contacted by collectors. They have a right to clear disclosures. Ending the Debt Collection Harassment Act reaffirms necessary protections and places control firmly back in the hands of consumers. We must do all we can to ensure that they are protected. And I want to yield the balance of my time to Representative Presley.
The gentlewoman yields to Ms. Presley.
Move to strike the last word. And
I thought Ms. Adams, you yielded to Ms. Presley, did you not?
Yes, I did.
That's what I said, Ms.
oh,
Presley.
okay, all right, thank you. Thank you for
You
yielding.
may proceed.
My colleague from North Carolina, thank you for yielding. To our colleague across the aisle, just to clarify, my bill won't prevent collectors from utilizing electronic communication. It just prevents them from weaponizing it, from abusing it against consumers who they're supposed to be protecting. It is entirely up to consumers whether they want to receive communication electronically. You know, ultimately, people are not opting out of something they don't even know that they've been opted into without their consent. This bill specifically amends FDCPA to state that consumers can consent to receiving information by methods other than by postal mail or phone. Consent is the operative word here. If my colleagues disagree that consumers should have to give consent in order to be contacted by collectors via text or email, they should just say that. That is perhaps more compelling than arguing the bill says something that it actually does not. My bill codifies what the CFPB has claimed it is trying to do, which is actually allowing consumers to opt out of a particular form of communication without having to opt out of all communication.
Would
I
the
yield
gentlewoman
back.
yield for just 1 second?
Sure.
For a point of clarification? I know it's the,
It's Ms. Adams's time.
Ms. Adams this time.
Yes, I'll yield to him.
Thank you. Just as a point of clarification, and I didn't mean to misspeak, what the bill does is it changes the default from an opt-out, which the consumer can do today, to an opt-in, whereas the default position is that it excludes electronic communication under this bill, and a consumer can opt in. We all know that almost nobody opts in and not very many people opt out, so you kind of use the 20% rule, and 20% might opt in, 20% might opt out, but that means most of the people will be excluded because they will not opt in. So that's just how the bill operates. I yield back to the gentlewoman.
Madam Chair, I want to yield back to Representative Presley.
Ms. Adams reclaims her times and yields to Ms. Presley.
Thank you again to the gentlelady from North Carolina. Again, just to reiterate, to be clear, the FDCPA already gives consumers the right to send a cease communication letter to collectors. All we are saying here is that consumers shouldn't be required to send a letter via certified mail, also onerous, just to tell a collector to stop contacting them. This is a nuanced, common sense approach to opting in and out of places control, placing the power firmly back in the hands of consumers. Whether it is in the mode of communication or how often they are contacted, the choice is theirs. I would hope that my colleagues who proudly championed a bill titled the Financial Choice Act would support extending that same agency to everyday consumers. I yield back.
Time is up. Is there any other further discussion of our amendments to HR 5021? If not, the question now occurs on approving the amendment in the nature of a substitute. All those in favor say aye. Those opposed say nay. No. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on ordering HR 5021 as amendment to be reported favorably to the House. All those in favor of approving HR 5021 as amended say aye. Those opposed say nay. In the opinion of the chair, the ayes have it, and HR 5021 is amended is
Recorded vote.
a recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. There is a sufficient second, and a recorded vote is ordered. Pursuant to Section C5 of Rule 3 of the committee rules, the vote on this question is postponed. The committee will now stand in recess until 10 a.m. tomorrow.